Picture this. You're in a courtroom, right? The tension. You could cut it with a knife. Years of police work, all this evidence, days and days of testimony. And it all comes down to this one moment.
Mm-hmm. Judge is summing up.
Exactly. The judge stands up, ready to give the final instructions to the jury. It's supposed to be the guide, yeah. Clarify the law, help them figure out the facts. It's fundamental.
Absolutely. It's the bedrock of a fair trial system.
But what happens when that guide, the person who's meant to be completely impartial, starts to sound less like a referee and maybe a bit more like one of the players?
Yeah, like they're picking a side.
What happens when the judge's voice seems to, I don't know, echo the prosecution's arguments, maybe even make them sound stronger?
Well, that's when you hit serious trouble, isn't it?
Mm-hmm.
It's the kind of thing you see in legal dramas, maybe the judge sort of stepping off the bench, metaphorically speaking.
Right.
You rely on that judge to be the neutral one, the steady hand. If that neutrality even seems compromised, it shakes everything, the whole foundation of justice.
And look, this isn't just some hypothetical worry. It's basically what was alleged to have happened in a very real, very significant case right here in Australia.
Mm-hmm.
So today, we're doing a deep dive into the story of Jason Troy McKell. He was a freight manager, had a position of trust apparently, and suddenly he's facing these incredibly serious charges. International drug importations, the works.
Yeah, and on the surface, the prosecution case looked, well, pretty strong. They painted a picture of a sophisticated criminal operation, and they clearly felt they had solid evidence pointing right at McKell.
That was the initial narrative for sure, but like often happens in these complex legal cases, the thing that really grabbed everyone's attention, especially lawyers, judges, academics, and took this case all the way to the high court.
Yeah.
It wasn't just about the alleged drug plot. It became about what happened inside that courtroom, specifically during the judge's summing up to the jury. The big question became, was the trial actually fair?
Exactly. That became the core issue.
Okay, let's really get into this, because the case, McKell v. R., it's way more than just one person's legal battle. It became a landmark decision. It's now seen as this critical cautionary tale, you know. It's woven into legal training, especially for young barristers starting out.
Definitely.
So our mission here is to trace that whole story. We'll look at the alleged operation that got McKell arrested, the trial itself, the appeals, the back and forth, and most importantly, understand why this case is now considered essential knowledge for anyone involved in our justice system.
It's a journey that really lays bare some fundamental principles about the judge's role and, well, the absolute necessity of a fair hearing for everyone.
Okay, so before we get into the nitty-gritty of the arguments, let's meet the key players, the dramatis personae, if you like. Who are the central characters in this courtroom drama?
Right. Well, first, obviously, at the center of it all is Jason Troy McKell. When he was arrested, he's 37. He's working as a movements manager for, coordinating shipments, goods moving under customs bond. It's a position of trust. The Crown alleged he exploited that position, and the charges were heavy. Commonwealth charges, so federal offenses, importing a commercial quantity of a border-controlled precursor, that stuff used to make drugs,
Right.
conspiring to import a commercial quantity of a border-controlled drug itself, and dealing with proceeds of crime over $100,000 in cash. Serious stuff.
And his defense? What was his story?
He claimed he was an innocent dupe, basically, that others had used him, that he got caught up in it all without really knowing what was going on. And the cash, that large sum found at his place, he said it was from betting on horses, legitimate winnings.
Okay, so that's McKell, the accused. Was he on trial alone?
No, he was tried alongside a co-accused. The sources just call him Mr. McGlone. He's apparently a former employee at YMAP, so there was a connection there, a previous link to McKell's workplace.
Got it. And the judge, the one whose actions became the focus.
That was Judge Michael King, SC. He was the trial judge in the District Court of New South Wales. He presided over the jury trial for both McKell and McGlone. And, well, his summing up is what sparked the whole controversy.
Okay. Then you've got the prosecution side at the trial.
Yes. Representing the Commonwealth, you had a Crown prosecutor, a senior lawyer from the Commonwealth Director of Public Prosecutions, the CDPP. Their job was to present the evidence, make the arguments for why McKell and McGlone were guilty.
And defending McKell at that initial trial, who was his barrister?
The records mention a Mr. Howell as counsel for McKell during the trial itself.
Right. So the trial happens, the jury gives a verdict, and then it moves upstairs to the appeals. Who was handling things for McKell at that stage?
Well, McKell instructed his solicitor first. That was Eli Rahm from Eli Rahm and Associates. Solicitors often handled the background work, the instructions, managing the appeal process.
And then they briefed the barristers for the court appearances.
Exactly. For the first appeal to the NSW Court of Criminal Appeal, or CCA, McKell's solicitor instructed a team led by Dean Jordan, SC. SC means senior counsel, sometimes called Silk. He was assisted by Ann Bonner, who's also referred to as A.L. Bonner in some documents. They were the ones arguing McKell's case at the CCA.
Okay, Jordan SC and Bonner for McKell, who argued for the Crown at the CCA, trying to keep the conviction intact.
That was Lincoln Crowley QC, also representing the CDPP. QC, Queen's Counsel, was the equivalent title to SC back then.
Gotcha. And the judges on that CCA bench, who heard that first appeal?
The panel was Justice Anthony Payne, J.A., Justice Stephen Beats Jones, and Justice Desmond Fagan. J means Judge of Appeal. And importantly, they didn't all agree.
Ah, a split decision.
Yes, Justice Payne and Justice Fagan formed the majority. They ruled against McKell. But Justice Beats Jones wrote a dissenting judgment, saying he thought the trial was unfair. That dissent became really significant later on.
A split decision, especially with a strong dissent, often signals it might go higher, right?
Absolutely. It flags a serious point of law in dispute. And it did go higher. McKell took his case to the High Court of Australia.
And who represented him there in the highest court?
It was the same team that argued at the CCA. Dean Jordan, SC, and A.L. Bonner. They took the fight all the way.
And the Crown defending the CCA's majority decision in the High Court.
The Crown team was led by W.J. Abraham, QC, and Lincoln Crowley, QC, was involved again for the CDPP.
Okay. And finally, the ultimate arbiters, the justices of the High Court who heard this case.
The bench for the High Court hearing comprised Justice Virginia Vell, Justice Stephen Gagler, Justice Patrick Keene, Justice Michelle Gordon, and Justice James Edelman. And their decision would be unanimous.
Wow, okay, that's the full cast. A lot of legal heavyweights involved. Now let's rewind a bit before we get tangled in the legal arguments. What was the actual operation the Crown alleged McKell was involved in? What did they say was happening?
All right, so the Crown's narrative was that this was a planned, pretty sophisticated scheme. And it hinged on McKell's job at YMAP. Remember, he coordinated shipments coming in, stuff under customs bond. Police were already watching them, apparently. They had wiretaps, surveillance, suggesting McKell and his associate McGlone were already persons of interest.
And the core of the alleged scheme involved specific shipments coming in from overseas.
Exactly. The prosecution focused on 3 consignments that arrived close together in May 2013. They argued these weren't isolated incidents, but part of a coordinated plan to bring in illegal substances.
Okay, let's break them down. Consignment number 1.
Consignment 1 arrived on May 16, 2013. It came from Chile. The paperwork said it was 5 boxes of pajamas. The consignee lifted was a company called Reach Ltd., which seemed to be fake.
Okay, pajamas.
Yeah. Now, the Crown alleged McKell intervened. Instead of letting the shipment go to the usual bond store, he told a YMAP driver to set it aside. Then, McKell apparently collected the boxes himself, put them in his own car, drove to an underground car park, and met McGlone there.
A clandestine meeting.
Seems like it. And then, weirdly, after the meeting, McKell took the boxes back to the truck, saying it was a mistake.
That is odd, but what makes this one really tricky is
That despite all the suspicious activity, the police never actually found any drugs or anything illegal in those 5 boxes. Nothing.
So what was the Crown's theory then?
Well, investigators suspected it could have been a dry run, a test of the system. Or maybe, just maybe, there was something illicit inside, but it got removed during that meeting with McGlone before the police could seize it. But critically, they couldn't prove it. There was no evidence of drugs. And this ambiguity became a major bone of contention later, especially with the judge's comments.
Okay, so that's the mysterious first consignment. What about number 2?
Just 4 days later, May 20th, consignment 2 arrives. This one's much bigger. 22 boxes, this time from Bangladesh, labeled as printing transfer adhesive.
And what was inside?
Not adhesive. Inside pails, within the boxes, police found crystalline pseudoephedrine, a huge amount, nearly 78 kilograms. That's a commercial quantity of a precursor, the stuff used to cook meth or other drugs.
Yeah.
And the listed recipient, a company called T-Shirt Printing Australia, said they never ordered it.
Okay, this one sounds more concrete. Did they link McKell and McGlone directly?
Yes.
Well,
Police surveillance caught McKell and McGlone meeting at a cafe. Intercepted calls suggested they discuss this consignment, number 2, and also a third one that was on its way. McKell was even seen using an iPad, apparently tracking the shipment's progress. And later that same day, McGlone was seen buying things flat-pack boxes, clear packing tape. The Crown suggested this was obviously for repackaging whatever was in the imported goods.
Right, getting ready to handle the pseudoephedrine. And the third consignment.
That arrived the very next day, May 21st, consignment 3 from Abidjan. This time, it was labeled as 2 boxes of shampoo bottles.
Okay.
And the recipient, Reach Limited, again the same fake company name as the first consignment.
Not shampoo, I'm guessing.
Definitely not. Inside the bottles, police found crystalline methamphetamine, almost 10 kilos of it, ice. The Crown put the potential street value, if sold by the kilo, at somewhere between $3.4 and $5.3 million. Huge money. And again, McKell was tracked using his iPad, seemingly monitoring this shipment too.
So the Crown lays it all out. 3 shipments close together, suspicious handling, meetings, precursor drugs, actual meth, fake companies, tracking. They're painting a picture of a clear, organized pattern.
That was exactly their argument. A sophisticated operation exploiting McKell's inside knowledge and access. He was, in their view, a key player.
So how did it all culminate in arrests? What happened next?
Well, things moved quickly after that cafe meeting about consignment 2. According to the Crown's evidence, McKell called the YMAP driver who had possession of those 22 boxes of pseudoephedrine.
Right.
In that call, McKell allegedly said something like, the shipment last week, consignment 1, was wrong, but this week's one, consignment 2, is the real deal.
Yeah.
He told the driver to collect the 22 boxes. Then, McKell met the driver and took possession of the boxes himself.
And that's when the police swooped.
Pretty much. As McKell had the boxes, which remember police had swapped out for empty ones in a controlled delivery, they stopped his blue ute, his utility vehicle, and arrested him.
Okay. And McClone?
The police then used McKell's phone to set up the prearranged meeting with McGlone. McKell drove his ute into the underground car park of his apartment building. McGlone arrived shortly after in his own white ute.
And they caught him red-handed.
Well, McGlone was seen lifting the cover on McKell's ute, looking inside at the boxes, the now empty boxes. At that moment, the police moved in and arrested McGlone, too.
So, both caught in the act, seemingly. What did the police find when they searched their properties and vehicles? What was the key evidence?
The searches turned up quite a bit that the Crown relied on. At McKell's place, they found 2 significant items. A handwritten note with details about consignment 3, the meth shipment, and that huge amount of cash, $400,150 in a lockbox in his bedroom.
Wow. Anything else?
In McKell's ute, they found rolls of packing tape. And significantly, other sources mention his fingerprints were found on tape for the packaging of consignment 1, the pajamas. That physically linked him back to that first, otherwise ambiguous, shipment. They also found 2 mobile phones in the ute. One had a note with details of both consignment 2 and 3.
Okay. And at McGlone's place?
At McGlone's home, they found empty pails, identical to the ones that held the pseudoephedrine in consignment 2, but these just had some harmless substance in them. And more cash, $4,000 in a robe and another $38,550 in a box.
So the Crown's view must have been, look at this. Coordinated shipments, communication logs, the note, the fingerprints, the tracking, the meetings, the huge amounts of unexplained cash. It all points to an organized system and McKell knowingly participating.
That's exactly the case they built. From their perspective, it looked like a very strong circumstantial case pointing towards guilt.
Right. So arrests made, evidence gathered, the wheels of justice start turning towards a trial. What were the first procedural steps?
Okay, so a joint indictment, that's the formal document outlining the charges, was presented against both McKell and McGlone in the District Court of New South Wales. That was on May 8th, 2016. But before the trial proper could start, there was a really important pretrial hearing.
Oh, what was that about?
It happened on June 7th, 2016, before a different judge, Judge Andrew Bailey, DCJ. Both McKell and McGlone applied to have evidence about that first consignment. The Chilean pajamas either excluded completely or strictly limited in how it could be used.
Because no drugs were actually found in it.
Exactly, and Judge Bailey made a crucial ruling. He agreed to limit the use of that evidence. Specifically, he ruled it could not be used as tendency evidence.
Tendency evidence. That means you can't use past behavior to say someone has a tendency to act a certain way, right?
Precisely. The ruling meant the Crown couldn't argue, well, McKell handled consignment 1 suspiciously, therefore he probably has a tendency to import drugs, which makes it more likely he was involved in consignments 2 and 3. It stopped the jury from making that kind of inferential leap based on the ambiguous first shipment.
That sounds like a significant win for the defense before the trial even started. It sets boundaries.
It absolutely did. It was meant to prevent unfair prejudice based on speculation about that first consignment. So, with that ruling in place, the trial itself kicked off the very next day, June 8, 2016. It was before Judge Michael King, SC, and a jury. and both McKell and McGlone pleaded not guilty.
Okay, so the trial goes ahead. Evidence presented, witnesses cross-examined, the whole 9 yards. And then we get to the critical stage. The judge is summing up to the jury. Remind us, what's the judge supposed to do here?
Well, the summing up is meant to be the judge's impartial guide for the jury. They need to review the evidence fairly for both sides, explain the relevant law the jury has to apply, and basically help them navigate the path to reaching a verdict based only on the evidence and the law. The judge should summarize the arguments, but not become an advocate for either side, especially on disputed facts.
Did Judge King start off okay? Did he give the usual instructions about the jury being the ones who decide the facts?
Yes, he did. Sources confirm he gave those standard directions. At the start of the summing up, at the end, and at points in between, he told the jury quite clearly, "You are the sole judges of the facts. If I express an opinion and you disagree with it, you disregard my opinion and go with your own view of the evidence." So formally, that framework was there.
Okay, the standard boilerplate was delivered, but this is where things apparently went off script, didn't they? This is the heart of the McKell case.
This is exactly where the controversy ignited. Because despite giving those standard directions, the way Judge King actually delivered the rest of his summing up raised serious concerns. The language he used, the points he emphasized. According to the later appeals, it seemed to shift from neutral summary into something else.
Something more like persuasion.
That's what the higher courts eventually found. It seemed he was advancing arguments, often echoing the Crown's case, but maybe even more forcefully, and sometimes suggesting conclusions or theories that perhaps even the prosecution hadn't pushed quite so hard.
Let's look at specifics. That first consignment, the pajamas from Chile, how did Judge King handle that, especially given Judge Bailey's pre-trial ruling limiting its use as tendency evidence?
Right. This was a major point. Despite the pre-trial ruling and the fact the Crown had apparently been somewhat cautious about speculating what was in Consignment 1 during the trial, Judge King seemed to resurrect the possibility in his summing up, and the language he used was striking.
What did he say?
He told the jury, and this is a direct quote cited in the High Court judgment, "You really have the possibility that there was something in it, Consignment 1, which was taken out, but of course never discovered because the police were still playing catch-up."
Okay, so he raises the possibility it contains something illicit.
Yes, but then he immediately followed it by acknowledging there is actually no evidence that there was anything in it. But then straight after that admission, he adds this suggestive comment. "You would think there would be little point in arranging for this to happen unless there was something in it."
Wow. So, no evidence, but you'd think there must have been something. That feels like a nudge, doesn't it?
A very strong nudge. And he didn't stop there. He linked it to his description of the whole operation as being run by an organization of great sophistication. The implication seemed to be that handling Consignment 1 this way was part of that sophisticated plan, suggesting McKell must have been knowingly involved in removing contraband, even though no one knew what, if anything, that contraband was. The appeal courts later saw this as inviting speculation and potentially the kind of tendency reasoning the pretrial ruling was designed to prevent, all based on the judge's "you would think" suggestion.
Yeah, that seems to sail very close to the wind, if not right over the line. What other examples raised red flags? There was a text message, wasn't there?
Ah, yes, the infamous tape trial text. This is a message McKell sent to McGlone on the same day McGlone was seen buying those boxes and rolls of tape. The text just said, "Don't forget to tape trial."
Okay. And McKell's explanation for that?
His explanation during the trial was basically, "I have no idea what it meant," and he vaguely suggested maybe he was talking horses, like recording a horse trial race or something. A bit flimsy, perhaps, but that was his explanation.
And how did Judge King deal with that in the summing up?
This became one of the most heavily criticized parts. The High Court described his commentary as using the forceful language of persuasion. He posed rhetorical questions to the jury. What was that in relation to, ladies and gentlemen? He brought up McKell's no-idea defense, maybe slightly misquoting it but capturing the gist, and asked pointedly, "Is not that, I suggest to you, a very revealing text?"
I suggest to you that sounds like counsel's address, not a judge's summary.
Precisely, and he explicitly linked it to McGlone buying tape that day. He questioned why McKell would claim no idea if it was innocent. Then came the killer lines. He's obviously not talking about horses, you might think, because it is so obvious, ladies and gentlemen, you might think that it is a reference to making sure that Mr. McGlone gets tape for the repackaging so that the substitution can be made.
So obvious. Again, very directive language. He's basically telling them what to think, isn't he?
That's exactly how the High Court saw it. They said, using terms like, "I suggest to you," so obvious, and you might think, In that context, it wasn't neutral summary, it was advocacy. It was like the judge was cross-examining McKell from the bench and forcefully dismissing his explanation, effectively arguing the Crown's interpretation for them.
Okay, that's pretty damning. What about the cash? The $400,000 McKell said was from betting winnings. How did the judge handle that part of the defense?
Right, McKell's defense tried to explain the huge sum of cash by pointing to his online betting accounts. They showed large amounts wagered, trying to establish him as a serious gambler who could have accumulated significant cash winnings, maybe from off-pick bets or other sources not fully captured online.
Okay, a plausible, if maybe hard to prove, explanation.
Well, the judge addressed this in the summing up. He did correctly point out a factual issue. While the online accounts showed a lot of activity, they actually reflected a net loss for McKell over the relevant time.
Now, pointing out a factual error like that seems okay for a judge, doesn't it? Part of clarifying the evidence.
Correcting a factual misstatement or clarifying evidence is definitely within the judge's role. But according to the High Court, Judge King didn't stop there. He apparently added comments described as biting sarcasm or mockery. He reportedly made a quip about not wanting to see an unsuccessful gambler, a remark the High Court later labeled gratuitous.
Gratuitous, meaning unnecessary, uncalled for.
Exactly, unwarranted. The High Court found this sarcastic comment went beyond necessary correction. Its only purpose seemed to be to belittle the defense counsel's argument and prejudice the jury against McKell. It was seen as a demeaning put-down that distracted from the actual defense point that cash winnings could exist separately from the tracked online losses. It undermined their attempt to offer any alternative explanation for the cash.
So it wasn't just one comment here or there. The argument was about the overall pattern, the cumulative effect.
Absolutely. That was the core issue that eventually won the day in the High Court. The criticism wasn't just about isolated errors, but that the summing up, looked at as a whole, lacked judicial balance. It wasn't impartial.
How so?
It seemed to consistently and strongly advance the Crown's case, sometimes using the judge's own persuasive theories, like the drugs and consignment one and the language of advocacy, I suggest, so obvious. But when it came to the defense case, while he might have listed their points, the summary often seemed immediately coupled with counter-arguments or dismissive commentary, like the sarcasm about the gambling. There wasn't the same persuasive reinforcement for the defense arguments.
So it felt one-sided.
Exactly. The argument was that the judge had effectively donned the mantle of the prosecutor, as the High Court later put it. It gave the prosecution the advantage of a second address, arguing their case again, but this time with all the weight and authority of the judge's position behind it. That's a serious imbalance.
That is incredibly serious. So as the summing up is unfolding, what's happening at the defense table? How did McKell's lawyers react?
They didn't just sit there. McKell's counsel, Mr. Howell, along with counsel for McGlone, acted during the summing up itself. They made a formal application to discharge the jury.
Asking to abort the trial. On what grounds?
On the grounds that the judge's comments had caused a miscarriage of justice. They argued the trial was now irrevocably tainted and couldn't be fair with that jury. They specifically pointed out the problematic areas, the consignment one speculation, the sophisticated organization comments, the forceful language on the tape trial text, and those sarcastic remarks about the gambling evidence. They laid it all out for the judge.
A very direct challenge. How did Judge King respond?
He refused the application. He decided not to discharge the jury.
Okay. Did he do anything else? Maybe try to correct the record?
He did make some further directions to the jury after refusing the discharge application. Importantly, he gave a specific redirection about his comments on consignment one. He explicitly reminded the jury that there was no actual evidence of drugs found in that shipment, and he told them to disregard any impression they might have gotten from him suggesting otherwise.
So he did acknowledge an issue there, at least partially. Did that fix the problem in the eyes of the defense or later the appeal courts?
Well, that became a key point in the appeals.
Yeah.
Yes, he corrected the consignment one comment, but critics argued it wasn't ideal. For one thing, it came quite a bit later in the transcript, apparently 29 pages after the original comment and after the discharge application. More importantly, though, it only addressed that one specific issue.
Right. It didn't touch the tape trial commentary or the gambling remarks?
Exactly. It didn't address the forceful, persuasive language used elsewhere, the sarcasm, or the overall feeling of imbalance. The defense argument, which the High Court ultimately accepted, was that general directions about the jury being fact-finders, or even this one specific correction, couldn't undo the cumulative prejudice created by the judge's overall approach and his other specific problematic comments. The damage, they argued, was already done.
So despite the defense objections and that one correction, the summing up concluded what happened next. The jury retired.
Yes, the jury went out to deliberate. They took their time. They were out for over 4 days, which suggests they were grappling with the evidence and the issues.
And the final outcome?
On July 21st, 2016, the jury returned their verdicts. Jason McKell was found guilty on all the charges he faced.
Guilty. Facing significant jail time, presumably. But McKell didn't accept the verdict. He decided to appeal.
He did. He instructed his solicitor, Eli Rahm, to launch an appeal against the conviction. On June 5th, 2017, the formal notice of appeal was filed with the NSW Court of Criminal Appeal, the CCA.
And the grounds for appeal, was it focused squarely on the judge?
Absolutely. The sole ground listed was, the judge's summing up to the jury caused a miscarriage of justice. It was a direct challenge to the fairness of the trial process itself, based entirely on the trial judge's conduct during the summing up.
Okay, so round 2 begins at the Court of Criminal Appeal. Who heard it, and what were the arguments this time?
The appeal was heard on September 15th, 2017, by that panel we mentioned. Justice Payne J.A., Justice Beach Jones, and Justice Fagan J. McKell's team, led again by Dean Jordan, S.C. with Ann Bonner, presented essentially the same core argument. The summing up was fundamentally unbalanced and unfair.
They focused on the cumulative effect again?
Yes, they argued it wasn't just isolated slip-ups, but the whole tone and pattern of the judge's comments suggested his own strong view of McKell's guilt. They went through the key examples again: consignment 1, Cape trial, gambling, arguing the judge crossed from permissible comment into advocacy, introducing his own theories, dismissing the defense case with sarcasm, and using persuasive language that undermined McKell's chance of a fair hearing. They argued those standard directions couldn't possibly cure such a fundamental flaw.
And the Crown's response at the CCA? How did Lincoln Crowley QC defend the conviction?
The Crown argued that trial judges have quite broad discretion to comment on facts, even forcefully, as long as they leave the ultimate decision to the jury, which Judge King technically did with his standard directions. They framed his comments as being within those bounds, maybe robust but acceptable, especially in a complex trial. They said he wasn't introducing totally new things, just drawing inferences, and that using phrases like "you might think" alongside the general directions kept the jury in charge.
Did they mention the strength of the evidence?
Oh, yes. They heavily emphasized that it was a very strong Crown case. The implication was clear. Even if the summing up wasn't perfect, the evidence was so overwhelming that McKell would have been found guilty anyway, so there was no substantial miscarriage of justice. This is related to the proviso concept in appeals, where an appeal court might uphold a conviction despite an error if they think the error couldn't possibly have affected the outcome. Crowley QC even described the judge's comments as typical and permissible in hard-fought trials like this one.
So, basically, judge was maybe tough, but fair enough. Jury was told they decide. And besides, the guy was obviously guilty based on the evidence.
That's a fair summary of the Crown's position at the CCA, yeah.
And how did the CCA judges rule on this?
As we mentioned, it was a split decision delivered on December 8th, 2017. The majority, Justice Payne J.A., who wrote the main judgment, and Justice Fagan J., who agreed with him, dismissed McKell's appeal.
They sided with the Crown.
Essentially, yes. They found the summing up was not unfairly unbalanced and did not cause a miscarriage of justice. They put a lot of emphasis on those repeated standard directions Judge King gave, saying the jury knew they were the fact finders. They also explicitly noted it was a very strong Crown case, suggesting this weighed in their assessment that the summing up didn't ultimately lead to an unjust result. But then there was the dissent. Justice Stephen Beach Jones completely disagreed. He wrote a powerful dissenting judgment finding that the summing up did cause a miscarriage of justice.
What was his reasoning?
Justice Beach Jones went through those specific problematic comments, consignment 1, tape trial, gambling, and concluded they absolutely crossed the line from neutral summary into advocacy. He found the cumulative effect created a serious imbalance that basically robbed McKell of a fair chance for the jury to properly consider his defense. He pointed to a troubling absence of judicial balance. He also specifically said the later correction about consignment 1 wasn't enough. It came too late and didn't fix the wider prejudice from the other comments and the overall tone.
So, a clear disagreement at the appellate level. Despite losing the majority vote, that dissent from Justice Beach Jones must have given McKell's team hope.
Absolutely. A strong dissent on such a fundamental point. The fairness of the trial is often the key that unlocks the door to the High Court. It signals a significant legal issue is genuinely in dispute among senior judges. McKell's team, Dean Jordan, S.C., and A.L. Bonner, applied for special leave to appeal to the High Court.
And special leave was granted.
Yes, it was, which in itself is significant. The High Court only takes cases it deems to involve an important question of law or public interest. Getting special leave meant the High Court agreed that the issues around judicial commentary and trial fairness raised in McKell were important enough for the highest court in the land to rule on.
So, off to Canberra for the final showdown. What was the atmosphere like at the High Court hearing?
Reports suggest the hearing, held in December 2018, was packed. Lots of senior lawyers, academics. The legal community was watching closely. This wasn't just about McKell. It was about a core principle of justice.
Yeah.
How far can a judge go in commenting on a case? What are the limits?
What arguments did Jordan, S.C., and Bonner make before the High Court justices?
They argued forcefully that the CCA majority got it wrong, and Justice Beach-Jones's dissent was correct. Their core point was that the summing up was fundamentally unbalanced, lacked judicial impartiality, and was essentially advocacy for the Crown. They hammered home those specific examples again: consignment 1, tape trial, gambling as proof. The judge crossed the line into persuasion, sarcasm, and prejudice. And they made a crucial argument about the effect on the jury. They said general directions like, you decide the facts, can't fix a summing up that is itself so persuasive and directive. They used the term overawing the jury, suggesting the judge's strong opinions and language could intimidate jurors, make them feel they had nothing to decide on those key points, or that disagreeing with the judge would be foolish or disrespectful. If that happens, the verdict isn't really the jury's independent decision anymore.
A powerful argument about the psychological impact on the jury. How did the Crown respond? How did W.J. Abraham QC and Lincoln Crowley QC defend the summing up this time?
They stuck to their guns, largely. They maintained that while Judge King's summing up might have been firmly expressed, it didn't cross the ultimate line into causing a miscarriage. They again pointed to the standard directions and the idea that juries are robust enough to follow them. They suggested the judge was just navigating complex evidence, and that the strength of the Crown case justified, to some extent, how it was summarized. They even hinted again that the proviso should apply if there was any error. It didn't matter because the evidence was so strong.
Did the High Court justices seem convinced by that line of argument?
The questioning from the bench suggested they were quite skeptical. For instance, Justice Edelman reportedly asked if the judge's comments effectively gave the Crown an unfair second address. Justice Gordon seemed focused on the cumulative impact, not just isolated phrases. Justice Gagler also expressed concern about the overall tone. The justices seemed very attuned to the practical risk of the judge's strong opinions influencing the jury's independent deliberation.
So the arguments were heard, the court deliberated. What was the final decision from the High Court?
On February 13, 2019, the High Court delivered its judgment, and it was unanimous. Every single justice agreed.
Unanimous. Wow. What did they order?
They allowed McKell's appeal. They overturned the CCA majority decision. They quashed Jason McKell's conviction, and they ordered a new trial.
A complete victory for McKell's appeal. A new trial means they agreed the first one was fundamentally flawed.
Absolutely. A unanimous High Court judgment sends a very strong message. They found decisively that the trial judge's summing up did cause a miscarriage of justice because it lacked that essential judicial balance.
What were the key pillars of their reasoning? Why did they find it unbalanced?
They agreed the summing up wasn't just a summary. It actively advocated for the Crown's case. They specifically called out the consignment. One comment suggesting drugs were there despite no evidence and contradicting the pretrial ruling as problematic. Even though it was later corrected, its presence and context mattered to the overall fairness. They were especially critical of the tape trial comments. They found the judge's language, I suggest, so obvious, was clearly couched in the forceful language of persuasion, not neutrality. That was impermissible advocacy. They also agreed the gambling comments went beyond necessary correction. The sarcastic, gratuitous remark was prejudicial, served only to belittle counsel, and distracted the jury. So the cumulative effect of all these things created an unbalanced summing up that undermined the defense. They stressed it wasn't just reflecting a strong Crown case, it was the judge advocating for that case. They drew that sharp line. There's a real and well-recognized difference between the statement of a case and the advocacy of that case, and Judge King had crossed it. And crucially, they affirmed that risk of overawing the jury. When a judge expresses strong opinions on disputed facts, jurors might feel they have nothing to decide or can't respectfully disagree. The High Court found that risk was real here, meaning the verdict might not have been the jury's own independent assessment, which is fatal to a fair trial.
It sounds like the High Court drew a very clear line in the sand about judges expressing strong opinions on disputed facts. Did they offer any general guidance for judges going forward?
They did. The judgment made it quite clear. The risk of unfairness is just too high when a trial judge suggests to the jury how a disputed factual issue should be resolved. They essentially said judges should refrain from doing that. It wasn't a total ban on any comment on facts, but it was a very strong caution against directing the jury towards a specific conclusion on contested points, especially ones central to the case. Impartiality must come first. The summing up must help the jury decide, not tell them what to decide.
So a huge outcome legally. What did it mean practically for Jason McKell himself?
Well, by the time this judgment came down in early 2019, McKell had been in prison for about 2.5 years based on that conviction. The High Court quashing the conviction meant the guilty verdict was wiped clean. He wasn't acquitted, the charges didn't disappear, but he won the right to a completely new trial, a fresh start before a different judge and jury, hopefully free from the errors of the first trial.
Do we know what happened after that? Was there a retrial?
The sources we've looked at focus on the High Court appeal
Yeah.
and don't detail the final outcome, whether a retrial actually occurred, if there was some kind of plea agreement reached, or if the prosecution decided not to proceed again. But the crucial thing the High Court gave him was that chance for a fair go, a trial untainted by judicial imbalance.
And the ripple effect. How did the legal community react to McKell v. the Queen?
Oh, it made waves, big waves. The unanimous High Court ruling instantly became a landmark case. It really clarified and cemented the rules around judicial summing up, hammering home that impartiality is absolutely paramount. Some commentators felt it brought Australian practice more into line with stricter views on judicial neutrality found elsewhere. It definitely sparked a lot of discussion. Legal journals published articles dissecting it. Dean Jordan SC and Ann Bonner even wrote one themselves for the NSW Bar Journal. That phrase, unbalanced summing up, really entered the criminal law vocabulary as a key danger sign. Law schools, continuing legal education providers, they all started using McKell as a case study. It became the textbook example of what not to do for judges and a crucial lesson for barristers on spotting and challenging unfairness.
Did the general public pay much attention?
Probably not widespread headline news in the same way as, say, a dramatic acquittal. McKell wasn't declared innocent, just given a new trial due to process failures. But for people interested in civil liberties, the rule of law, the integrity of the courts, it was a really important decision. It showed the highest court taking a very strong stand for procedural fairness, even in the face of serious charges and seemingly strong evidence. It underscored that the system has to police itself to maintain trust.
Okay, so it's clearly a massive case with huge implications. Let's really focus on that cautionary tale aspect. What are the absolute key takeaways for aspiring barristers, the ones learning their craft right now?
Right. There are some critical lessons here. First, and maybe most importantly, stay vigilant and be prepared to object respectfully but firmly at the time. Remember McKell's trial counsel, Mr. Howell. He made that application to discharge the jury during the summing up, even though Judge King refused it then. Making that objection was vital.
Why was it so important?
Because it put the issue on the record. It gave the judge a chance to correct himself, which he did partially on consignment 1, and crucially, it preserved the point for appeal. If counsel hadn't objected then, it would have been much harder, maybe impossible, to raise it later. This case screams, if you think the summing up is unfair, you must raise it with the judge then and there, usually with the jury out of the room, to protect your client and the trial's integrity. It takes courage, but it's essential. Second lesson, how to handle a challenging judge, hot bench. Look at Dean Jordan SC and Ann Bonner. They had to argue against the trial judge's conduct, then persuade a dissenting judge at the CCA, and finally convince a unanimous High Court. Their success shows that barristers need the skill and conviction to argue fundamental principles, fair trial rights, even when facing judges who might seem skeptical or feel entitled to express strong views. It's about respectful but clear, firm advocacy on core principles.
That makes sense. Any lessons for the prosecution side, too?
Yes, I think there's a subtle but important one for Crown prosecutors. The Crown won at trial, they won the majority at the CCA, but ultimately the judge's overzealous comments, sometimes going beyond even what the Crown had argued, led to the whole conviction being thrown out. It highlights that for an ethical prosecutor, the goal isn't just a win, it's a fair win. A conviction from an unfair trial is inherently unsafe and vulnerable on appeal. So prosecutors also need to be mindful of the trial's fairness. In really extreme cases, they might even need to consider gently distancing themselves from improper judicial remarks to protect the integrity of the process and the safety of any potential conviction.
Fascinating. So McKell really serves as a guidepost for everyone in that courtroom, judge, defense, prosecution, about maintaining that crucial balance.
It really does. It reinforced the boundaries, clarified the rules, and gave barristers clearer guidance on how to navigate these incredibly difficult situations when they arise.
So the story of Jason Troy McKell ultimately becomes this powerful reminder, doesn't it? That the fairness of the whole process is absolutely paramount, and the judge's role. It's to be the impartial guy, the umpire, not a second advocate pushing for one side, especially when it comes to the facts the jury has to decide.
Mhm.
It really makes you think about that delicate ecosystem in the courtroom. The judge guiding, the lawyers advocating, the jury deciding, how easily that balance can be tipped and what the consequences are, not just for the accused person, but for the public's faith in the entire justice system. Thinking about this case, does it make you look differently at where the line should be drawn for judges commenting in a trial?